Okay, now it's good morning, everyone. And we have a brief time with Ledge Council, to review draft 6 point something, of, the, pre-K language. Now I'm calling it pre-K language. And it is draft 6.2, and it is on our webpage. If, Katie and Beth, if you want to join us, that would be great.
Awesome.
Seeing it, so, yep.
Oh, you can stay. Perfect.
Okay. Brief was good.
Mhm.
Sentence.
Yep.
Two. Okay, welcome.
Morning.
Good morning.
I think that we're just going to have you walk through the changes that you made. And so members, after the discussion with JFO yesterday, we're taking out as part of our work, the language on all the stuff that we had started to make changes on weighting and all of that kind of stuff. And you'll see some language that's being inserted here, which our discussion later after Ledge Council leaves will be what are the like 5 or 6 key elements that we want to make sure are considered in that work of the entity that JFO will contract with. So welcome.
Yeah, Katie McLean, Office of Legislative Counsel.
Beth St. James, Office of Legislative Counsel.
So we'll just start walking you through it.
Yeah.
Yesterday you asked for new legislative intent language. It is the intent of the General Assembly to ensure that pre-K education is included as an integral part of Vermont's education system. The right to education is fundamental for the success of Vermont's children in all grades, pre-K through grade 12.
Perfect. Yeah.
Can I just make a note there?
Please.
I borrowed the right to education is fundamental from section 1 in Title 16, so it's a nice synergy.
Awesome.
Okay, so the next several sections all amend section 829, which is your pre-K section. If you notice, I added the reader heading with the dates up above, so you understand that we are amending this section at different times. So first we have the amendments that take effect July 1, 26. And these are mostly changes to subsection C, the pre-qualification section. So you have language about joint rulemaking. Starting on line 3, the agencies jointly shall determine whether a private or public provider of pre-K education is qualified for the purposes of this section and shall include a qualified provider and a publicly accessible database of pre-qualified providers available on the agency's websites. And then in subdivision 2, this is where we have language about the teachers. So in subdivision 2A, this pertains to private providers. A private provider will employ or contract the services of at least one teacher. That's maintaining the status quo. And on lines 14 and 15, you have the addition, including through the issuance of provisional and emergency licenses. And subdivision B, this is specific to public providers. Pre-kindergarten education provided by a licensed public provider pursuant to this section shall be provided by a teacher who is licensed and endorsed in early childhood education or early childhood special education under chapter 51 of this title. And then
Is that weird? Pre-kindergarten education, pre-K education provided by a licensed students shall be provided by, I guess.
the double provider.
Yeah.
I got caught on that too. And then in the 2033 amendment, when we're referring to both public and private, I found a way to sort of tighten it up. But it would persist like this for a couple of years. Okay, and then we don't have a change to the registered family childcare homes this year. Also effective July 1, 26 is the background checks. If the employees of a pre-K education program operated by a school district have completed a background check pursuant to this title, DCF shall deem any requirement for a separate background check for the purpose of pre-qualification pursuant to this section to have been met.
So this is an attempt. We went back and forth about, we, meaning, Ledge Council and me, about how to, try to address the issue of public school teachers having to have two background checks. And Rep. Garofano is gonna share this with, DCF. And I suspect that we'll get feedback that it doesn't work. But if we can have Janet maybe come Zoom with us a little bit to explain why, then that would be helpful. And I don't, you know, I know this is me being stubborn. I don't think we can accept I don't think we can accept this just the way it has to be, argument.
Can I read something that Janet had sent? Or
It's
do
a
you
little
wanna-
bit out of, no, because we only
Okay.
have these folks for 30
Okay,
minutes.
that's
and,
Yeah,
I just want to get,
I'll see if Janet.
I just want to get through. Yeah, that would be helpful.
Just one
Just a
quick-
second. Got Doug and then, yeah.
So, Madam Chair, on this language, and I'm a little bit out of my depth, but I thought yesterday in our conversation, we thought that DCF's requirements would be the stricter of the two.
Yes.
So holding it to that.
So, we switched, so the answer is yes to that. We switched because, of the, and we haven't had a chance to fact check this yet, but, people who were listening, said that on the education side that, there was federal issues around, there's federal requirements around background checks in public education. There is also on the CDD side, the difference being that there's no child development money going into pre-K. It's education fund money. So that's why I made this switch. Now, that's the argument I'm going to make to Janet when we have her, and she's going to have a contrary argument back.
That was my exact
Okay.
question, what covered.
I'm sorry, may I add something?
Yeah.
So section 255 of Title 16 is the statute that requires background checks for school, anyone a superintendent is going to make an offer to. There is a subsection K, that states the requirements of this section, meaning the background check for employees of school districts, shall not apply to superintendents and headmasters of independent schools with respect to persons operating or employed by a childcare facility as defined under 33 VSA 3511 that provides pre-K education pursuant to section 829 and that is required to be licensed by DCF. Superintendents and headmasters are not prohibited from conducting a criminal record check as a condition of hiring an employee to work in a child care facility that provides pre-K education operated by the school. I bring this to light because I discovered it last night when I was drafting and we did not have a chance to talk about it. So I drafted the language we talked about, but I suspect that this statute or this subsection may be a place to work with instead of new language in 829. But I didn't know off the top, I didn't know if pre-K providers operated by a school district fit that definition of childcare facility. And so this section would automatically apply. So I'm just bringing it up that there is already a piece of current law that may fit into this discussion.
I not having read that, but listening to you, what I believe that is intended to do is to avoid private pre-K providers having to have two background checks. And so I'm not sure why we wouldn't do the same thing on the public side.
Right.
So yes, and. So it might be that we add language to that and do the reverse thing versus having this
Exactly.
separate standalone
Exactly.
language. Thank you. And that, can you send us a reference, or just make sure Katie has it, the language, yeah, so, when we talk to Janet, we can, sort of have full information, thank you, that's helpful. Okay, Katie, let's keep going.
Okay.
So next we're amending the section again, this time July 1, 2033. So this is our pre-qualification section. And then we move to where we have the teacher licensing. So we strike through the language in paragraph A about private providers. And then everybody's following the same standard in B. Pre-K education shall be provided by a teacher who is licensed and endorsed in early childhood education, et cetera. So we're not specifying what type of pre-qualified provider it is. Also, striking through subdivision 3, creating a separate standard for registered family childcare homes. So everybody would be falling into this category B as of 2033.
How this is organized is much easier to follow
Okay.
than the previous version.
Yeah.
Yes.
Just quickly, the standards that were expressed just previously, is that also gonna, also for home providers?
Are you talking about the background check?
No,
The
Licensing?
the licensing and all that, does that
Yeah.
also apply for home providers
In 7 years,
in 7 years? Okay.
yes. Because we learned from the data that we got from DCF that the majority of them already have it, and those that don't are working towards it.
Okay.
Okay. So next we're amending this section again, and this time it's upon the contingency. I might switch off with you, Nova.
Okay, where are we? I'm sorry.
That's okay, page 5, unless we keep going.
And we say that that's meaning contingent upon other
Yes.
legislation and
Yes.
effective dates.
So section 4 are the big substantive, not all of the big substantive changes, but it is the entire section 829 where we've made amendments. And those changes would only take effect on July 1, 2028, if the same conditions that are needed for the foundation formula are also met. So it's essentially taking effect if the foundation formula takes
Takes
effect.
effect.
Yes.
Just a comment about the mechanics. So you'll see when we get to subsection C of this section, which is where all the pre-qualification and teacher language is, we've omitted that. It's just ellipses. And that is so the changes that you've made in the previous 2 sections and the timelines you set out, the contingency won't affect that. Those would happen regardless, if that makes sense.
It will if the money happens. The equalization of the payments to private providers.
Okay.
You understand what I'm saying?
Totally.
Okay, so I'll wait till we get to this section to see if I might be saying something that doesn't need to be said, so
Okay.
I will.
So page 5, subdivision. Oh,
Yeah, I get it. Sorry, the rates, the companion language.
yes.
I'm sorry if I missed it.
Sorry, we're speaking in code. So that code, I'll uncode that. When Katie just said, we pulled out all of that, and so that the qualification section sort of stands alone with their effective dates. And that would go into effect regardless of the contingency language. And I said, well, that depends, because we can't require the higher qualifications without the higher payment.
Right.
That's what I was referring to.
And on a separate point, and I may have, this is, yesterday we were talking about the check back language, that's 4 years out, we'll check back.
Yes, there's in 4 years, a report that we haven't seen the whole thing yet. So let's
Okay, that's all.
hold on to that, because my guess is that they've included it someplace a little further down. Yes.
We have a solution.
I know, that was quick.
It was, we have a solution. I think it's been traveling in some language, not all language, just by virtue of both of us being in the document.
Okay.
Pre-kindergarten child, we're on page 5, line 1, we're in the pre-K statute, the definitions subsection. Here's your change regarding eligible to enroll versus not yet enrolled. So on line 3, this should really be highlighted, but I am not good at highlighting. It's 3 or 4 years of age or is 5 years of age, but is not yet eligible for enrollment in kindergarten. And then I think we can wordsmith this however you like. Right now it reads, provided, however, that if a school district in consultation with a parent or guardian determines that a child who is 5 years of age who is eligible for enrollment in kindergarten is not yet developmentally ready for enrollment. I think that's the phrase that I would appreciate feedback on. Such child shall be eligible for pre-K education funded pursuant to this section.
I think it works.
Yeah, I also think it works.
Yeah.
Developmentally ready is not something that is in my wheelhouse. So, great. Subdivision 2, this is a change we made in the last section, but I don't think, or last draft, but I don't think we went over it. So pre-kindergarten education means services that are publicly funded pursuant to this section and everything that is currently in current law. We're keeping line 17 on page 5, we're keeping this to 10 hours a week.
Yes.
We're going to jump to page 6, subdivision 3. Here is some language that we played with to make it more clear that a school district is responsible for ensuring access to pre-K education by assisting a family to identify a pre-qualified private provider located within the district or in another district, or a pre-qualified public provider located in another district with capacity. So we've listed out all of those options. And then school districts are encouraged to maintain a position or collaborate with other school districts to maintain a shared position for a pre-K education coordinator.
Mhm. Thank you.
Page 7. If the supply of pre-K providers is insufficient, then we're requiring a school district on line 7 shall begin or expand a program to satisfy that demand and may work in collaboration with AOE and the local Building Bright Futures Council to meet with neighboring school districts and private providers in the region to develop a regional plan to further expand capacity, including through the issuance of provisional emergency licenses.
So we talked about sort of putting that piece first, like, and I thought we said shall, but work with the Agency of Education and Human Services and Building Bright Futures Council. I think that what we wanted is sort of that kind of meeting of the minds to happen before we say you shall begin to expand, you shall begin or expand a program.
So is it that they shall work in collaboration and then if necessary, a school district shall begin or expand?
Yes. Yes. Because I think that if necessary part is, and the reason that I think it's important to have that consultation with those entities first is because of really some of the stuff that we heard yesterday sort of pinpointed it for me. But so if a private provider closes down in their region, a school district is not going to necessarily automatically going to be able to immediately provide access. And so there needs to be, some way for that to be dealt with and
Put heads together fast.
right.
So I had a question
Yeah.
here and I don't know the answer, so I'm gonna put it out.
Mhm.
Do the UPK coordinators have a role here? Or do they only have, I also think they have a role here to kind of ensure, like find the right provider that might be able to take over, you know what I mean? Like, so.
Well, I mean, when you say the school district, they are employees of the school district.
Okay. I just didn't know if we wanted to be more explicit about the UPK coordinator here. Because not, like, we're encouraging them to do it, but I think that it would be worthwhile saying that we want the UPK, if there's a UPK coordinator, we want them to be involved in figuring out capacity as well.
So you're saying,
When there is not enough capacity, because that's one of the things that they do, is making sure, it's not just helping,
I get it.
access, it's
I get it.
also ensuring.
I just didn't know how specific we needed to say. So like, if we say it's the school district, are you wanting to call it out because it's a particular expertise?
It's a particular expertise and because not everyone has it right now. So
Right.
if you just kind of say the school districts, I think it kind of elevates that this is kind of a needed thing that we're encouraging school districts to do.
If it's mentioned more than once in the statute. Are you suggesting, language that says, where it says, school district? I guess it would say something after school district, it says,
Yeah. before shall.
including pre-K coordinator, if present, or if there is one, or,
Yeah.
some other language like that.
Looking at Ledge Council, hoping.
We can just add to the list of folks involved in the collaboration. Pre-K.
Including pre-K
Yeah.
coordinator.
Okay, we can make that change and get you a new draft. So far, I think that's oh no, we have to make the effective date change too. Okay. Tuition budgets, average daily membership. This is a, again, language that should be highlighted and isn't. On page 7, lines 19 through 21, removing reference to the district's academic year because we're moving towards a statewide school calendar.
Right.
As Chair Wood mentioned, this draft removes all of the funding changes that have previously been traveling in drafts. And so we're keeping the concept of average daily membership. So,
And we're keeping that concept because we don't know exactly what to change it to yet. But we're going to be asking for information about what to change it to, if we should change it.
Yes, question about the removal of that calendar language.
Yeah.
What do we gain from that? And I guess with some concern that absent that, does it leave some ambiguity as to when this could take place? Even if we move towards unified calendar, it doesn't seem like that would run counter to the language in here, but right.
Well, the language here says that the district is setting its own calendar, and the district isn't going to be setting its own calendar.
I think we could just say, if there is a concern and if you would like to see a change, we could say, provided, however, that the district shall pay tuition for weeks that are within the academic calendar instead of the district's.
Meaning that it would be the state calendar.
Yeah. Yeah.
That's deleting districts and just saying the academic calendar. And
We can say
maybe just statewide. Yeah, we were thinking the same
Statewide,
thing at the, say pinky swear.
We'll need to be watching that though, to make sure that the statewide calendar actually goes into effect, right?
Exactly.
Otherwise, a whole new
Yeah,
bucket of troubles.
yeah.
Well, so would we be better off by just making it the academic calendar? Because then it would have meaning whether we move to a statewide.
Yeah, because that would cover both.
That would cover either, whatever the
Then we
law
wouldn't
is in
have to
effect.
be as diligent, like, not that we wouldn't be diligent, but
You could also say, I think maybe within the school year. Academic it is the statewide school calendar is what is in Act 73.
Does that when does that take effect?
I think 2028, I can look it up.
If it's not postponed.
Who the heck knows what's gonna happen on education?
Right.
Yeah. So why don't we omit statewide and just say academic year, or academic calendar, or whatever? Remove reference to the districts, and just keep it broad.
Okay. We're on page 7, line 21. Tuition paid under this section shall be at a statewide rate, which may be adjusted regionally, that is proposed annually through a process jointly developed and implemented by AHS and AOE. Annually, the agencies shall present the proposed statewide rate as part of their budget presentations for approval by the General Assembly as part of the budget process. 11 through 12 are highlighted simply because I removed strike throughs because we're keeping the concept of average daily membership. So I just wanted to highlight that that concept has re-entered the conversation. I did keep the subdivision 2 repealed because under the foundation formula, there are no longer voter approved budgets.
Mhm.
So that language would no longer be applicable. And then subdivision 3 is the same. I've highlighted that for the same reason. We had previously struck that because of the average daily membership reference, and now we're keeping current law. And here we have the language in subdivision 4 on page 9, sorry, do you want me to just keep going?
You're doing great.
A pre-qualified private provider, current law is specific to the pre-qualified private provider receiving additional payment. Now we've changed that to make it clear that either both a private provider and a public provider may receive additional payment directly from the parent or guardian for childcare services. So we reworded the whole, it's really just inserting public provider, but we reworded the whole sentence. So it just reads a little easier. I'm very excited to report that in the next draft you have, this green will no longer be green. I reached out to Janet McLaughlin last night, and I am happy to report back that I received very clear explanation for what this language is used as, the in-kind. So Janet reports that this is something that AOE monitors most closely. And so I'm just going to start by saying everything I'm telling you is a game of telephone. I have done no independent verification. And so I would highly encourage, if you have more questions, to talk to both AOE and TCF. But it sounds like this is perhaps a school district is providing in-kind space to a private pre-K provider that's using public school property, or the school district is providing the licensed teacher to the pre-qualified provider. And the in-kind reference means that if you count all of the kiddos that should be receiving the Act 166 funds for that private provider, there is perhaps a discount on the money that is going from the district to the private provider to cover what would have been rent or salary or contract fees for the teacher. So that's the in-kind piece. So all of the kiddos are counted the same in the average daily membership. They're funded the same through school budgets, but there may be district to private provider agreements that mean that the school district is providing some kind of in-kind service that results in not the full tuition payments going to the private provider.
Which the district made, in kind as a component. Statewide tuition. Okay, so I get the first part of the sentence now. As a component of the statewide tuition established. Meaning that the school district includes those expenses as part of whatever they submit to the state to determine the statewide rate for tuition.
Yeah, yes, I don't know off the top of my head, the statewide rate calculation is set in rule, and I don't know what that, if it includes student counts, then all of those students would be counted regardless of how much money is going to the private provider.
Yeah, go ahead.
I guess, perhaps I misunderstood. I thought I heard you say that the school district can discount the payments they make to the private provider by the amount of the in-kind. So rather than, if it's $3,900 a student, they can make a payment of less than $3,900 to account for the contracted with teacher or space.
That is my understanding. So if the private provider was entitled to $50,000 at the statewide rate, but then they would have to give $10,000 back to the school district to pay for rent or to pay for the services of the teacher. Instead of having the money go both ways, it would just be a $40,000 payment to the private provider. That's my understanding. And I wouldn't have even close to this understanding if Janet wasn't also on her email at 9:00 last night. So a large thank you to her.
That matches the language as.
The language on its own,
clear,
right,
yeah.
the language on its own doesn't,
There is
is very difficult to understand, but, understanding implementation of it is, easier. Okay, thank you. I think we can move on from that.
Great. There will no longer be that green there.
So, will we, in fact, do we need all the rule stuff?
No, I think we can probably put some asterisks in there
Yeah,
in the next draft,
we're not changing that.
correct?
So there is a change, BBF asked for under the rules, it's on page 12.
Oh,
And they want
Yeah.
added to that monitoring,
I'm sorry, where's that?
page 12, line 5.
5.
So after DCF, they want add BBF there. Because they are charging.
They are doing it,
monitoring,
yes.
they're doing that, and that's just the.
You could still cut out most of the
Yeah,
language.
And put that in, yeah.
And then we jump right to page 13. Subsection H is going to be entirely repealed. The provision that allows school districts to set geographic limitations on where they're paying pre-K tuition pursuant to this section.
Because whatever is agreed to will be a region.
Right.
And we didn't want to have competing regions, a pre-K region and then some other school region, so.
And then I just want to highlight on the bottom of page 14, those 3 asterisks there represent new language we've added previously regarding the background checks.
Okay,
Because that took effect before the changes in this section take effect. So depending on what we do with that background check language, there may be nothing to add here.
okay. And we forward that background check language that Beth gave us to Janet so she can look at it before. Okay, and this, the status report, Doug?
Page 15, line 2, section 5. Do you want to talk about this or do you want me to just keep going? Okay.
So this is a status report back, coming January 1, 2030, before the 2033 changes take effect. CDD is to submit a status report to Human Services and Health and Welfare, assessing private pre-K providers' readiness to comply with the changes in that section 3 that we looked at.
I would add education committees to that.
And then section 6 is a JFO pre-K report, but it's not JFO doing the work, it's a contractor. And I have run this language by JFO already and it's good with them. The Joint Fiscal Office shall contract with a contractor with expertise in Vermont's education funding system to make recommendations regarding how to account for the provision of pre-K education within Vermont's foundation formula. This language is taken directly from Act 73 and a similar to request to the contractor JFO is currently working with for how CTE fits into everything. So we're mirroring the ask. The recommendations shall, to the extent possible, align with the recommendations of the report required to section 45A of Act 73, which is the big JFO contractor report regarding the foundation formula. So we want to make sure if they are using a different contractor, we need whatever the pre-K recommendation is to align with whatever the other recommendations are.
Be good.
And so this is where we, as a committee, are going to have some discussion about what are the, key elements that we want to be the outcome of that report. So this is where we would be putting in equal payments, accommodation for administrative costs of the district, and whatever else, other things that we come up with. But so rather than us, and whether we should, go with a weighting and per pupil thing versus the C word,
Oh gosh.
categorical. I always want to say contingency or some other word, but categorical grant. So we're going to lay out, we'll reach agreement as a committee on the, probably at most 4 or 5 items that we want to make sure are the outcomes of this work. Okay, so that's why you don't see any of the payment stuff in here, because I think we reached a conclusion yesterday that we lack sufficient information, and actually the body lacks sufficient information to make that determination on our own. We need somebody who has some expertise in this to help before we just decide to make changes that could have unintended consequences. Okay, so that's what this is about.
The report back date is January 15th, 2027, and that was at the request of JFO, that date. And then there's a $50,000 appropriation. So we should probably add appropriation in the next draft section heading. But there's a $50,000 appropriation to JFO from the general fund to hire that contractor. Effective dates. Katie's reader assistance headings were really helpful here. But we are going to make changes. Do you want to?
Yeah, so I think that I think A can stand, but B is gonna be combined with what is now C, so that we can have a contingency apply to the July 1, 2033 changes also. And previous drafts have a version of that, so we're just gonna go back
So the
to.
question that I was
Yes.
making sure about the payment has to align with the contingency. Okay. So I feel like we're in a really concrete place now. The one big question we have is around this background check thing. And Janet is able to come, Janet McLaughlin, Deputy Commissioner, is able to Zoom in with us at 11. So we'll have an opportunity to hear from her and have that discussion. And Ray forwarded her the link to the language that Beth found, and I'm sure she can pull up this version and see what language that we put in here. So I'm asking now, because we will need to take a straw poll on this language before we forward it on to the Education and Ways and Means Committees. If there's anything other than the 4 or 5 points about what we want out of the study or the report, are there any outstanding elements besides those two things, the background thing that we'll get clarity from Janet on, and us coming up with the 4 or 5 things that we want to put here in that next to last section? Yeah, go ahead.
My main concern is the cost, the taxpayer, but we don't get that before we do the straw vote, right?
We're not going to have that at all until we see this in the major ed bill. This will be a policy section that goes into the education bill that the Committee on Education is working on. So the only cost that we know for sure about this is this $50,000.
Okay. Because I don't mind moving it on, I just worry about the taxpayers.
Of course, yes, we all do.
That's why it's only a straw poll rather than a vote,
Yeah.
because it's not actually a bill we're passing. We're just.
I don't mind moving it on, but
Yeah,
at some point we'll have a say.
we will, because actually we will receive the bill back in our committee. Because once it is officially introduced as a bill on the floor and gets a number, because we have jurisdiction about this area, we will have an opportunity to take another vote on this.
Okay.
Okay, so I think that we're pretty steady. The only two things is, we'll let you know the outcome of the conversation with Janet. And then we will come up with in a little bit, the sort of like 4 to 5 things that we want for outcomes or to be considerations of the report. Okay?
I'm only booked in one committee today. So if you need me for, I may be easier
Yeah.
to get things,
Okay.
depending on what Katie's doing, just reach out to Matt.
Okay. All right. Sounds good. Thank you both for sticking with us and our on again, off again conversations. So it's really appreciated. Okay, folks, we are going to take a diversion to S210, an act relating to access to autopsy reports. So we talk about pre-K.
One end of the spectrum to the other.
I tell you, whenever I explain what we do in our committee, I always say that it's prenatal, pre-birth to after death. And here we go. That's where we're at. So we have Judge Zone, and then we have Kim McManus. So Judge, welcome to House Human Services.
Thank you for inviting me. Good morning.
Morning.
Tom Zone,
Chief Superior Judge, and I took the liberty of watching your discussion on this during the walkthrough last week.
There you go.
So if it's okay with the committee, what I will do is I think I'll go through and answer some of the questions I think you've had. And obviously, if you have additional questions, please let me know.
Awesome, thank you.
So the first topic I would touch on is on page 1. It's lines, well, actually, I'm sorry. I switched on. Page 2, lines 7 through 12. This is the question about, I believe Representative Donahue asked, we'll call it veto power. That's a policy decision. The statute, as it would come in, does say, and the state's attorney does not object. In other words, it appears that if the state's attorney does object, the judge has no authority to order something. If your committee believes that should be different, certainly you can change that. My understanding is the basis for that type of position by the state's attorneys was that it related to ongoing investigations or cases involving criminal charges that were pending. And the appropriate concern that the state doesn't want to have those investigations or charges interfered with. And so if your decision in the committee is, well, we don't want the state to have veto power, but we do want the judge to be able to recognize this other issue, there is a solution. And I did have a chance to speak with Kim McManus about this. I won't speak for her, but if I'm saying anything wrong, she can look over and start wagging at me. Go, stop.
She'll have her time in the chair too.
So you could go and delete on line 9 the language from the comma after report, and the state's attorney does not object. It would then say, if the Superior Court finds the petitioner has demonstrated good cause for the petitioner to obtain the autopsy report, it shall order the office of the medical examiner to provide it. And then down below, there were a number of factors that have been considered. Mm-hmm. And Ledge Counsel was correct. I believe those factors came from Wyoming. I think it was, there's a couple other states, but I think Wyoming had a set of factors. And what you could do on page 3 is after Roman 5, little 5, add another one, 6, that says whether the disclosure of the autopsy report would interfere with an ongoing criminal investigation or criminal proceeding. So you bring that language in, it provides the state's attorney the ability to bring that to the court, but it takes away the veto power and allows the court to make that decision. And I think that language would address that issue.
Representative Bishop?
To me, that seems to get at part of the issue, but I wonder if we also couple it with sort of a time limit, that can be lifted after a while. There may be good reason in the moment for the judge to agree with the state's attorney, with that good reason not applying a year from now or 2 years from now. The resolution of the matter that the state's attorney is handling would probably lift the objection.
I would think that would be a new petition or a new request or a request to reconsider, something like that. I do not see that a judge making a decision, for instance, on March 1st of 2026, if the state's attorney's investigation is completed, that they couldn't come back to the court and say, Judge, that's now gone. That impediment that you found, that you weighed that fact. But that's a very good point.
But it doesn't actually say in the bill that if denied, that the petitioner can resubmit with new evidence or new.
That's correct.
So maybe we should state that. Yeah.
Some bills do say, some statutes do say that if, for instance, with sealing expungements, if denied, you cannot do something again in the future. So the absence of language like that in itself signals that someone can come back, and the judge would have the authority to address that. If you put that in here,
Yeah.
it could theoretically be used to give questions about, well, what about statutes where they don't say you can come again? And so
Okay. All
I
right.
don't know that it's necessary.
All right.
There was also a question about on the factors. And on page 2, in particular, the factor of line 17 and 18, whether the disclosure is necessary for the public evaluation of governmental performance. What did that really mean? As I understand it, it looks at cases where there may have been allegations or concerns of excessive force. Did the police or whoever respond appropriately? Was there a death in a correctional facility? And Was there possible governmental negligence that caused an issue? And so that factor looks at those types of areas.
All right, that's helpful.
The other question that was asked is about the factors. How are they considered? Think of it like a scale. Factors are weighed, not counted. You have a scale as opposed to, let's say, a scoreboard. And so when a judge looks at 6 factors, for instance, it doesn't say, well, there's 4 here. One party theoretically could have 4 factors on their side, but the other 2 factors are so significant that they outweigh it. And so factors are weighed, not counted. And if you think of the scale, if you're missing something, in other words, if there's a factor that means nothing or is not relevant, it's not penalized. You don't lose anything. It just doesn't add any weight to the scale. It's neutral.
Mhm.
And so there's nothing, having the factors the way they're structured here, the absence of a factor being relevant to a particular case it's not considered. It just doesn't add any weight. So we have, when you look at in Vermont, for instance, on parent-child contact and parental rights and responsibilities, the legislature has enacted statutes for us to consider the best interests that are based upon consideration of factors. It's similar to that, and the court has indicated that factors, again, are to be weighed, not counted.
That's helpful. Thank you.
And the final point that was raised, and just did not come up on the Senate side, I was asked, is there a fee? Because under 32 VSA section 1434, subsection A, there's a number of fees for probate filings. And so is there a fee? And if there is a fee, how much? A number of those filings, I understand from trial court operations, it's anywhere from 100 to 150. And so this would go in, it looks like, as A35. If the committee decided to have a fee, petition for access to autopsy report.
Go ahead.
Who pays for the fee?
The applicant,
Okay.
if they
No, that's
have,
okay.
if there are financial difficulties and they're deemed, we call it to proceed in form of pauperous, the court does have the authority to waive the fee.
Okay, thank you.
You answered all of our questions, and let's just see, were there any other questions that popped into people's heads as Judge Sonne was?
Of course.
Bishop.
To revisit the question I raised, and not to upset the apple cart with respect to other statutory provisions. Don't want to get in that position. If we look at line 11 on page 2, provide a copy to the petitioner in whole or in part and may place restrictions on the petitioner's dissemination of the copy provided. We add, or the timeline upon which they shall receive the report, or something like that. That will allow for a delay, rather than, it would keep it on the docket, if you will, for an opportunity to revisit without a refiling. Is,
Because then they were gonna have to pay another fee.
yeah, possibly another fee, different judge, just some way to try to put a limitation on when they receive it.
There's another way to address that too, though. If you added a subdivision that talked about a fee, you might be able to accomplish both things with that. To say, a fee shall be charged.
And we don't want this to go to Ways and Means.
Okay,
So, yeah.
so
No.
forget the fee.
Yeah.
I'll tell trial court operations I said that. No.
Yeah.
Decision. My only concern with that is it sounds like what's going to be happening is the judge can say, well, you have to release it, but in 6 months. And so in whole or in part, and may place restrictions on the petitioner's dissemination of the copy provided. That talks about once they get it. That's not about when they get it.
Right.
And so that doesn't address the issue of whether or not there's an investigation that you're waiting for. That would be the section before. It shall order the Office of Chief Medical Examiner in whole or in part to produce it.
On a timeline that is, I don't know, cognizant of an ongoing.
Separate sentence after. I understand you're saying that it's not in the place where Representative Bishop had suggested it. It doesn't really go here, but if there was a separate sentence that.
If you put something in that went along the line, and the states that Kim may have some ideas on this too, but if you wanted to say a court may something to the effect of the court in its order may direct that upon a certain, may
I would
upon.
say completion
On the
of
completion.
criminal proceedings or something,
But there might be another factor that weighs in like that too.
yeah.
That I can foresee that if I was sitting on the bench and I'm hearing something, I might say, well, today, that factor is important. 6 months from now, it doesn't weigh the same for whatever reason.
Yeah.
Now, the criminal investigation is the easiest one to point out, but I'm not sure that that's the only one that could potentially be like that. And so if there was a way to come up with language that said, usually when I come up with language, I walk around and my wife if I'm at home, my wife will go, what are you walking for? So I'm thinking.
Are you mumbling at the same time?
But language that basically says that they can ask the court to reconsider upon a change of circumstances, something like that. Or, this shall not, nothing in this section shall be construed from a petitioner requesting the court to reconsider a prior determination based upon a material change in circumstances. A material change in, in information contributing to the factors, something like that.
Something like that.
That I think would get you with.
I think so.
We'll do that.
So alleged counsel writing very quickly. Thank you.
Thank you. Any other questions for Judge Zone on this? Thank you, Judge Zone.
Thank you very much.
Appreciate it. Kim.
Good morning.
Welcome.
Hello, I've never been in here.
I know, so we're gonna do a brief round of introductions
Oh,
because we haven't met
Kind of
you either, so. My name is Teresa Wood. I'm from Waterbury. I also serve Fulton, View Score in Huntington.
Good morning, Dan Noyes, represent Wolcott, Hyde, Johnson, and Belvedere.
Hi, good morning. Eric McGuire, representative for Rutland City.
Brenda Steady, East Milton, Westford, and I used to work for a funeral home. So.
Doug Bishop, Colchester's Chittenden 20 District.
As Michael, represent Hartford. Julie McGill, and I represent Bridgeport, Middlebury, New Haven.
Ray Garofano, I represent Essex and Essex Junction.
Lori Morris, Committee Assistant.
Sapphire at Action Circles.
Katie McLean, Office of Legislative Counsel.
I'm
We've met
Katie
via
via email.
Great. Thank you for being here and welcome.
Thank you so much. For the record, my name is Kim McManus, and I'm with the Department of State's Attorneys and Sheriffs. And again, yes, Ledge Counsel Katie McLean checked in with me when this was on the other side in Senate. And I have to admit, she caught me at a moment where we had just a million things popping off. And my comments, whoa, like we need to be able to like stop the release of this report were made before any draft that had these considerations. And as the judge stated, this was our main concern. If we're ordering an autopsy report, it is because there have been suspicious circumstances for the death. Otherwise, we don't order them. So we have a vested interest in these reports, and for a number of reasons, we would want to keep these reports safe. And depending on how we need to use the report, either again for the investigation purposes or at the criminal proceeding, which, as you know, can take quite some time. I think an interesting piece, as the judge mentioned, we had some quick back and forth when he said, whoa, you want veto power? And while we would love veto power sometimes, that would be wonderful. We do appreciate that the judge put up a hand on that one. We do think adding the consideration of whether there's an ongoing criminal investigation or criminal proceedings into the factors will allay 99.9% of our concerns. And I think depending on why the person's asking for the report, I think the redaction piece is going to be very helpful. Because and I don't actually know why someone would be requesting this, but if there was an insurance claim or a civil suit or something like that, and we did not want the vast majority of the report to be released, because it might impact witnesses or some part of our trial. And that's where I think, depending on our concern and the person's interest in having that report, maybe some of that timeliness issue could be addressed in the redaction piece. So the judge being able to weigh, oh, you need this, you really need this, which says this, but we can also redact all of this, which is evidence in a criminal case. And if not, then if our consideration outweighs the other interests, then the person might need to wait.
And so I appreciate sort of the circumstances where, excuse me, I got a tickle in my throat. Where that came about, and it did seem a little odd to us that the state's attorney could essentially veto whatever the judge might do. Or that's the way it seemed. I know, right? You know, you'd probably like to see that in other sections of law, right?
Spread the word.
Spread the word. Actually, I think we'll be taking the words out.
Yeah.
So you're okay with the judge's suggestion that we add the state's attorney's consideration as one of the things that the judge considers when making their determination.
Yes, and again, Judge Zone and I communicated and we came up with that language. So again, as long as that is foremost in the list, judges need to consider it. If it's in the factors, it has to be considered. That'll satisfy our concern.
Great. Any other questions for Kim or clarifications? Thanks so much. We appreciate that.
Thank you for having me up here in the tower.
Yeah. This is, it always works wonderfully when, this is the benefits of having things on YouTube. You know, people can go back and listen and they can come up with solutions before they arrive. So that's awesome. Thank you. Okay, so Katie, let me ask you about your time frame.
Sure.
Because I think this is a bill we can, we've essentially just done markup.
Yeah.
So I think we can, move to a possible vote, but I want to give you time to do whatever you need to do, so.
Yeah, let me jump back here. Let me just understand. So you want to we're going to strike the language about the orders,
Yeah.
and then we're going to add the B5. Were there any other changes you wanted to make that were mentioned, or just those two?
The last one that Doug was talking about and where the.
Trying to write quickly.
Yes.
Nothing in this section shall prohibit a petitioner from refiling a petition upon a material change in circumstance.
Circumstances or information.
Okay,
I'd say information, I think.
a material change in information. Okay. And you want to vote it today?
It doesn't have to be today.
Okay.
I just was looking for timeframes from you. We can do it tomorrow.
I have to run down to Senate. I might have a little window before noon. So I'm also making the pre-K changes, so I'm gonna prioritize that.
Priority.
And then I'll do this and
So we have it tomorrow.
it'll have to be edited.
Yeah, if it's, tomorrow's fine.
Okay,
Yeah.
that's easy.
Okay. All right, folks, so let's take a break. And let's take about a 15-minute break. And then, actually, I'm going to reverse that. We'll take a break in about a half an hour. Let's see if we can get to our consideration. We'll take a break before Janet comes on, okay? Let's see if we can come up with the 4 or 5 elements so that we can give those to Katie and Beth, and then maybe the next version that we have back will be a version we can vote on.
You want me to stay?
I don't think you need to. Somebody will email them to you. You're right.
Can I ask, Madam Chair, if you could reframe the issue we're discussing? I have found the categorical versus weighted very confusing.
Okay,
So
which is exactly why we're asking somebody else to help us with that. Okay, so go back to the bill, and go back to page 15.
Yeah.
And so after yesterday's whole discussion with the Joint Fiscal Office, it became crystal clear to me that even though, Ways and Means had sort of put a bug in my ear about this categorical. I always want to say contingency, and it's not that. Categorical grant versus the weighted, average daily membership. that I think that neither one of us have sufficient information on which to make a decision about what's going to achieve what it is that we're looking for.
Right, what meets our goals?
Right,
Yeah.
what meets the goals. And so, so what this is, JFO already has a contract signed with an organization. They we heard from them yesterday that they have a regular weekly call. They'll bring up this issue. They believe that it probably could be an add-on to the contract that they have, which is good because then they're considering the whole pre-K to 12. Again, that goes to our intent language.
Right.
We're trying to make sure that the other bodies, other committees are looking at pre-K to 12, not just K to 12. So what we need to do is in this report, so we have the language that is requesting the report. We want to add language that says these are the elements, these are our goals, you know. We want them to consider how to best provide equal payments to private and public, a system that would provide equal payments to private and public. That's one thing. That would account for administrative costs of a school district in working with and ensuring access to pre-K is another item.
And administrative costs at the other end, at the private providers.
Well, that's why but the school district has administrative costs that the private providers don't. They're going to have to contract with more private providers than the school district's going.
In some instances.
It depends on what the regions look like.
Well, right, and because they have to,
You don't have to raise your hand, we're just having a discussion.
they're responsible for assuring access. They're responsible for that
Yep.
whole role.
Giving them that
Absolutely, yeah.
responsibility.
Right, that
Yeah.
responsibility is.
This just came across. New York State is putting together a pre-K plan, $4.5 billion. So Vermont, that's why I always ask about money, because I can't imagine. That's in New
There's not
York.
more of them.
I know, I feel sad
Millions of
for their
people.
taxpayers.
Yes, they have a lot more
They have a
people.
lot more people to be.
I
paying
know,
tax.
but they're a lot.
Yeah, but yeah.
Remember, not everybody pays taxes. It's the ones that pay the taxes that are paying for all the free stuff.
So, yeah, I heard that on the news this
A lot of
morning.
people rent.
Okay. Okay, so what are the other elements that we would want to make sure are considered in that?
That it supports achieving access for all 3 and 4-year-olds in the state in a mixed delivery system.
Mm-hmm.
That you had equal payments and equal standards.
Right, equal educational standards for
That,
teachers in the classroom.
right, that it be fully integrated with a pre-K to 12 system.
That'd be, well, I'm not
Yeah,
sure
not
about the
integrated, that's not the right word, but
but that the cost is included in the cost
There we
of
go.
education.
right,
There's actually good list in that Act 76 report on the pre-K education implementation committee put
Yeah,
together.
well, what else did we
Well, they
say?
have
What else did we
They
say
have a
back
bunch
then?
of stuff in there,
Yeah.
so, you know, it's
That was
like,
we. That was
Yeah, I
us.
know.
We did
I know.
that.
so I'm just, maybe there's some parts in here, and also,
That'd be good.
it doesn't look like that this ends, like that group that was putting together. I was just trying to look at the membership of that committee, so maybe even, you know, this particular committee also is charged with looking at it again in.
We didn't give we didn't
No,
give
they
a
didn't
date
give-
that they
It
ended.
doesn't look like it. There's parts of it that end, but.
Yeah,
some of
I
it
think
doesn't.
that the official
But-
pre-K implementation
Yeah.
committee has ended, but they still are, there's,
That membership,
well, we know that they're doing work, that I forget the
Yeah.
job title of the person who was here with the secretary, but, and we know, because we heard from Building Bright Futures and from, CDD, that they are meeting on a more regular basis all around
Much better
pre-K.
partnership.
I'm
Yeah.
happy to run through the,
Yeah. Yeah, run
Run
through.
through.
all right, so the needs
Say
of
it
the.
slowly,
I
so
will.
we can decide which ones we
The
want.
needs of both state and local education agencies. the minimum number of hours that shall constitute a full day for both pre-kindergarten and kindergarten.
Okay, but so are we wanting to do that piece?
I think we're already saying how many hours.
You're saying 10.
Saying how
We're
many
saying
hours.
10.
But do we say, is that the right number?
Right?
I-
Well, we know, we've heard it's not the right number, at least for 4-year-olds.
Okay.
They concluded that it's not the right number.
Whether.
We don't need to ask that one
Yep,
again.
nope, that's fine. Whether there are areas of the state where pre-kindergarten education can be more effectively and conveniently furnished at in an adjacent state due to geographic considerations. So looking
Oh.
across state lines.
That just reminded me.
Yeah, we need to
We
add
have to
that
add the
piece,
St.
yeah.
Johnsbury piece and the Northeast Kingdom piece.
Benchmarks and best practices to ensure high-quality pre-kindergarten education.
What the other one, just when you were talking
Yep.
about adjacent states, it made me just think of, maybe one of the things we should be asking them is around, a focus on, areas of the state where access or participation is limited.
Say that again.
To have them focus on, or to provide recommendations around increasing access and participation, in areas of the state where either or both of those are limited. So in the Northeast Kingdom, they have actually more access, but participation is limited, so we don't know if people know about pre-K. And in Franklin and Grand Isle counties, access is an issue because they have insufficient capacity.
Yeah.
Okay, keep going.
Benchmarks and best practices to ensure high-quality pre-kindergarten education.
Okay, we don't need that.
Number 5 is measure to ensure capacity is available to meet the demand for pre-kindergarten education.
Yeah. That's a
That's that.
more general one, but we say with a focus on what I just said there before. Yeah,
Yeah. So we've already captured that.
Yep.
yeah.
Special education services for children participating in pre-kindergarten in public and private settings.
So feel,
Yeah, I don't think we need to do that either.
Any necessary infrastructure changes to expand pre-kindergarten?
Well,
well, it's either within the school or they partner, right? Like,
Mhm.
right, I
So-
feel like that's part of honestly the broader conversation about what's gonna happen, what kind of districts we're gonna have and whether we're gonna,
infrastructure.
right.
Costs associated with expanding pre-kindergarten, including fiscally strategic options to sustain an expansion.
I mean, that's kind of related to the last piece we discussed about how, and I don't know if this study can even get into that. How do we have a system where districts who need it and want it can do full day, for instance, that versus the equity of, wanting to fund equally, but there's that piece that we have talked about, but
And I go back, I feel like I'm of two minds about that.
I am too. And
I
so
like, yeah, I can see where it might be necessary, and then boom, I'm thinking like, then that's another equity issue for me.
So do we, is this something we would be asking the contractor to look at, what would the mechanisms be? And I think probably not, because it's really more embedded in policy.
In policy.
If
yeah.
the policy decision was made in one direction, we'd need to know, how would you address that within the funding formula?
I mean,
But we're not there yet.
no, it honestly probably lands in whether the foundation, is the foundation formula gonna go forward? So
Right.
if it's gonna go forward, then school districts will have the ability to make policy
Yep.
choices
Right.
within what they receive.
Priorities
Right.
among the
Among all
different
the different
things.
things.
I mean, I'm also of two minds, but I think that if we have a foundation formula, I think it would be fair for a school district or a region, whatever,
Whatever,
and
yeah.
to determine what their priorities for their communities are.
Because they
And
will differ.
They will
Right.
differ,
Yeah.
and I think they need to make those choices on their own
Yeah.
within the foundation formula that they receive.
And is there anything about weights in there? Is this
Well,
an
right, so
opportunity
this
to
is-
have them look at weights?
Yes, so we need to, the sort of like the big question that maybe we lead off is whether we should be looking at a categorical aid
Mhm.
payment structure or a weighted
Mhm.
average daily membership structure.
That's kind of along the same lines as what this is really talking about.
Yeah.
All right, and recommendations for oversight of the pre-kindergarten system,
Okay, we've already decided.
and
on
then the lovely catch-all, any other committee, anything the committee deems relevant.
that. So, yeah.
We should probably put something in there, like if, while they're, like, what
Shall
didn't we
I
ask?
think what we do is shall consider at least, and then,
Right.
or including,
Yep,
you know, so,
see if there's anything, I'll just go through, but yeah, those
Yeah.
are that's it,
thanks
so.
for referencing
I'll
back
just see
to
if there's
that.
anything
It's always
in
good to
here
look back at
about
we've
what
already
else.
Hmm.
What did they find is the what else? Like somewhere in this report, 106 pages.
done. Yes, I read the report,
Do they,
a while ago.
yeah, I know, that's why I'm like,
Yeah.
any other issue the committee deems relevant, I'm sorry. Relevant, so I don't know way down the end if there is anything.
Well, I think that for us, because they're talking about utilizing a contractor that is really solely looking at the financial
Mhm.
aspects of it. So they actually did provide a whole bunch of information about best practice and all of that kind of stuff, that I think that's not what we'd be asking this contractor to do. This scope is more narrow.
So let me read what we have
Okay,
so far.
okay.
I have whether we should look at a categorical aid payment structure or weighted average daily membership. We want whatever policy we have that supports achieving access for all 3 and 4-year-olds with equal payments and equal educational standards. It should, a cost is included in the full cost of education and provide recommendations on increased access and participation in areas of the state where either of those are limited.
Aren't we at the first one you listed isn't part of the list per se, because the underlying question is what funding mechanism will meet our criteria? And that's not a criteria, which, should it be,
Right, sort of the overall question is
Yeah.
what funding mechanism.
Yeah.
And they may have something different. They could, we've thought about categorical and average daily weighted
Right.
membership, but there could be something that's
and that's
another
the-
option.
That's the overlying question, but
It
then
is.
we have to identify what are the goals that we want them to be considering in looking at which funding mechanism would meet those goals, would best meet those goals. And I think we want to reference the commitment to a mixed delivery system.
Yeah,
And they're looking at how to fund it, because might be a very different answer if it's all public.
I like that. Emphasizing that.
Do we even go as far as to look at outside impact? So for instance, does the expansion of pre-K or a private pre-K have anything to do with access to water and wastewater in that community? Because some of the limiting factors could be access to infrastructure, especially in rural parts of the state. So if
Yeah.
a school wants to expand or a private provider wants to expand, but there's no municipal water. Totally limiting
that's what mini
factor.
chip is for, or whatever it's called.
Does that
I
get,
agree.
does that get a little too into the weeds?
Yeah, that's not good. I don't think, that's not for this.
So I've revised it
Okay.
to elements for the JFO contractor. Overall question is what the appropriate funding mechanism is, and then in parentheses, I'm putting categorical aid payment structure, weighted average daily membership, or other recommendations, considering the following goals. Supports achieving access for 3 and 4-year-olds, equal payments and equal educational standards, ensures The costs including full cost of education, provides recommendations on increased access and participation. So really not provides, just increased access. Increased access and participation in areas of the state where either of those is limited.
Well, access to all. We want access for all 3 and 4-year-olds, no matter where they are geographically.
But I think it's worth highlighting what you said, because there's places where there's access.
We need to do something
but-
different in those places.
Yeah,
that
because
have
there's
limited
slots, but
access
people
or-
are not.
Oh, right,
using
should
them.
there be a different approach?
Yeah.
Right.
So the first one says supports achieving access for all 3 and 4-year-olds.
Okay,
So
you got
that one
that already.
kind of.
Yeah.
All 3 and 4-year-olds have access.
And did you say mixed delivery system?
No, that's
Yeah.
what I missed. Okay.
Support, continues to support a mixed delivery. So we've talked about access, we've talked about equal payments, we've talked about 3 and 4-year-olds, we've talked about professional qualification. Is there anything else that people think? I think that's a good start. I want to send that off to Beth and Katie. Okay, all right, let's take a break. So we're going to, I think just to let people know sort of what's on tap, we have another long day today, this afternoon. And we have our cadre of folks here who are bill reporters on the floor this afternoon. So please try to watch the calendar and listen for when our bills are on the floor so that we are all present when we are on the floor for our bills. And we obviously will not be coming back here after floor. Tomorrow morning, of course, now we're going to have a whole bunch of third readings. I didn't look and see yet what's on the notice calendar for tomorrow. Anybody, let me just look at that for a second. I'm just trying to decide, honestly, about, I'm hoping that we have language back today on pre-K. And it's at 1 o'clock. She's trying to fit everything in is like a puzzle that is difficult. So I'm going to ask if people would be willing to come at 9 a.m. tomorrow to vote on the pre-K language. It's not too early, is that all right? Okay. So I think that's what we'll do, because I'm trying to figure out how we're gonna fit in our celebration, how we're going to do that, and S210 is not, we don't have to pass that. We don't have to pass that this week, but if we're able to get to it tomorrow, we're able to get to it. And Lori, I think that we can go offline. We're gonna have a little break.